Lord, may I once again request your Lordship to revisit Berubari for a minute, Lord, where we had stopped yesterday. Lord, that is PDF, Lord, volume 13, page 492, at 508, para 31. Volume 13, 492, at 508, para 13. 31, para 31. That para 31. Last 10 lines. That's not very crucial because that's exactly what has happened. 370 is a clear, I would say, reflection of this viewpoint that 8 justices of this court have taken.
Running page 608.
My lords have got it?
1 minute,
However, it may be added, is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In other words, the question as to how treaties can be made by a sovereign state in regard to a cession of national territory and how treaties when made can be implemented would be governed by the provisions in the constitution of the country. Stated broadly, the treaty-making power would have to be exercised in the manner contemplated by the constitution and subject to the limitations imposed by it. Whether the treaty made can be implemented by ordinary legislation or by constitutional amendment will naturally depend on provisions of the constitution itself. Now, Lord, in my respectful submission, the treaty in question here between the erstwhile ruler and Lord, the Governor General, which ultimately, Lord, that has now been transfixed into Article 370. So, Lord, 370 is an extraordinarily unusual provision. It's never, Lord, I mean, it's something which is so beautiful that, Lord, the constitutional framers felt that how do we give, Lord, a kind of respect, kind of acceptability, kind of, Lord, validity to this, Lord, letter of accession. So they, Lord, devised, as I said yesterday, Lord, it was an absolute, Lord, brilliant statesmanship on their part to bring that into constitution to assure people of Jammu and Kashmir that we mean what we say. We are not going to do away with this. So, Lord, that's why, Lord, this is very important that treaty will have to be interpreted in the light of 370. It's now, Lord, virtually, Lord, transposed into Article 370. Now, Lord, in the light of this discussion, please see, Lord, at page, para, and this becomes even more important now. Therefore, our conclusion is, and Lord, in my respectful submission, Lord, no, it's a view which is, Lord, inescapable, and Lord, it binds your Lordship since, Lord, this is a judgment of a bench of 8 learned judges. Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purpose of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that law necessary to implement the agreement has to be passed under 368. Now, concession follows the conclusion. So, Lord, it can't be said that it is on a concession. The conclusion of your Lordships is very categorical that legislative power is not possible. Only a constituent power can be exercised in respect of this. And that constituent power is under 368. So, Lord, in my respectful submission, far from President exercising the powers, and I will show, Lord, why President had become functus officio. But, Lord, even assuming that, Lord, 373 survives, which it doesn't in my respectful submission, even then, Lord, the power could only be exercised under the constituent power. No other way. Lord, this is a little important because your Lordships rightly, Lord, raised the issue as to, Lord, the definition of union territories in Article 3. Lord, originally it was not there. It was brought subsequently by, I think, 17th Amendment to the Constitution. But your Lordship said states do not include territories. Kindly see that. Page 516, page 513, para 40. My sincere apologies. It is significant that Article 3 in terms does not refer to the union territories. And so, whether or not they are included in the last clause of Article 3A, there is no doubt they are outside the purview of Article 3B, C, D, and E. In other words, if an increase or diminution in the areas of the union territories is contemplated, or alienation of their boundaries or names is proposed, it cannot be effected by law relatable to Article 3. This position would be of considerable assistance in interpreting Article 3C. So, Lord Parliament then amended, and it that I have sufficiently been instructed, briefed, and educated by Mr. Prashant Bhushan in this matter over several sessions. So, because he is appearing with me, and so Lord, it's something which I must not say that it is. Now, Lord, please turn back to that para that I was reading, para 47 at 5 and 6, on 10th line from the top. On the other hand, it is clear that if the law in regard to implementation of the agreement is to be passed under Article 368, it has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house. And that is a safeguard provided by the article in matters of this kind. Please see the language. But this is the protection your lordships have extended. And I beseech your lordships to extend it further. Lord, some kind of executive power, authorize president to do this. Lord, do away with everything that Article 3 provides in the garb of Lord 356 powers. It makes complete mockery of constitutional safeguards. Because your lordship knows what majorities can do. We have seen, Lord, what happened in 1975. So, Lord, this is the check. And that's why, Lord, constitutionalism, your lordship's, Lord, duty to, Lord, the constitution, to, Lord, ensure that it is upheld by the executive and parliament in letter and spirit. If they don't do it in letter and spirit, this court will strike it down and must. So, Lord, these words, Lord, I now see answers, Lord, to the reference which was sent by the Honorable President. We would accordingly answer.
Everybody was decided at a time when explanation 1 and explanation 2 were not on the constitutional.
They came as a consequence. Your lordship said.
They came as a consequence of Berubari.
Correct.
To take into account what the court held, that the state would not include a union territory.
Correct.
So now really that issue will not survive because the whole basis was that state will not include a union territory. And therefore, you couldn't see that territory in exercise of the lawmaking power under Article 3. You had to amend the constitution.
That's what there are two submissions on this. One, that treaty to be interpreted in the light of what constitution provides in respect of that treaty. And two, that if you want to now touch that treaty, you cannot do it by a legislative act. You have to do it in exercise of a constituent power. Constitution is durable. But if it served the need of the hour on that day, doesn't mean that that need must be wished away. Lord, in my respectful submission, the argument that Lord government is advancing before lordships, Lord, does not bear out from plain reading of the constitutional provision. Now, see, Lord, chapter 21, the title, temporary, transitional, and special provisions. Now, Lord, I accept that 370 is temporary because it's titled temporary.
Yes.
But it is temporary from the perspective of J&K, not temporary from the perspective of the Indian Dominion or Indian Republic. The choice was left to the Constituent Assembly and therefore the people of J&K to decide whether you want to continue with this status or you want to be away from India. That was the choice, and I will show that note from Mr. Iyengar's, Gopalaswamy Iyengar's note, a very express statement before the Constituent Assembly. So, Lord, he was chairing the committee which drafted Article 370. There were 8 members in it. And they did it because of the extraordinary situation. They realized that we are losing J&K out of our hands. Now you persuade Lord, citizens of a state, a country, at that time an independent state, to cede to you. They agree to cession. on clear
There
understanding.
is a question of persuasion by,
Sorry,
it was the Raja Hari Singh who requested the government of India that
I
time.
agree. No question about
No,
it.
you are
But
saying
the
that the-
conditions,
that-
historical conditions can't be lost sight of. Your lordships are right. Raja requested, but in that letter, he expressly asked for this protection. In that letter, he expressly asked for this protection. The Governor General agreed to that. And that is why the Constituent Assembly debated.
That's what Mrs. Sibal argued, that after 1954, this 370 has become a permanent
Yes.
feature of the Constitution.
Now just see below. Just see below 370. Below 370 is below what? Below first and foremost, 370 is below that below Article 371C is most important. That's first. The provisions of Article 1 and of this article shall apply in relation to that state, meaning thereby all other articles will not apply. That's an emphatic statement in the Constitution. Article 371C. We have to begin journey of 370 with that. Then they go forward and say in Article B, after that in D, such other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. So, only Article 1 and Article 370 were expressly applied. All other articles were to be applied by the President, subject to this exercise of power under D, and read with the proviso. Provided no such order which relates to matters specified in instrument of accession shall be issued except in consultation. So if it is part of instrument of accession, in consultation. If it is outside the instrument of accession, concurrence of the state government. Now, state government here must be understood in the context of democracy. It cannot be